You will have 15 minutes to present your arguments. As I explained to everybody, when I'm presiding, you can't mention the names of victims, and you can't mention the names of children, refer to them in a way that doesn't identify them. Also, you will have your full 15 minutes, and I'm trying to think if there's anything else I want to say. I don't think so, so you may proceed. Oh, just identify yourself.
Okay, thank you. May it please the court, Cole Bond on behalf of William Gibbs. This incident arises out of a traffic stop and a subsequent search of a vehicle. This traffic stop occurred at night when it was dark outside. Just to, I guess, summarize the issues, there's really two issues. One's the search of the car, and one is the questioning of Mr. Gibbs that led to, or was the trooper's basis for conducting the search of the car. So there's two troopers on the scene, Trooper Knowles and Trooper Fowler, and there's a dash cam of Trooper Fowler's cruiser, which shows a lot of the traffic stop. So initially the issue is Trooper Fowler testified at the hearing that one of the reasons he stopped Mr. Gibbs' truck is because he was swerving and almost collided with multiple vehicles. When you watch the dash cam video from his cruiser, it does not show that. And Trooper Fowler was in a median where he did a turnaround, so I guess that could have happened before he turned around, but that part was not on the dash camera. In regards to speed, there's no real way to determine what the speed is, so that's something we can't disprove with the dash camera. So after the traffic stop's conducted, another trooper, Trooper Knowles, arrives on the scene, and he immediately starts to search the truck. He testified he was just watching traffic to make sure no one hit them, and he was also conducting a plain view search. One of the issues for Mr. Gibbs is the plain view search. While he was conducting his plain view search, he entered both the passenger and driver's window with his head to look inside the vehicle. Judge O'Brien in the trial court, her ruling was, she noted that he entered the driver's side window and the cartridge was found on the passenger side floor, so that didn't constitute a violation because that's not.
Did you're indicating she found he entered the video. I understood Judge O'Brien to have found that it did not appear from the video that he did in fact enter the vehicle, and therefore, since I couldn't see it on the video, I found the officer's testimony credible that he did not go in the video. Did she make a specific finding that she entered she went inside the vehicle before he did the plain view?
Her order says Knowles lawfully looking into the vehicle of the truck versus crossing the threshold of the window. I'm sorry.
I see what you're saying in the second page.
Yeah, I believe she said it was just the driver's side window. She didn't find it was the passenger window, so that wouldn't have led to the discovery of the cartridge.
I guess to follow up on Judge Stevenson's point, and I had a similar concern that Judge Stevenson did, and that is, was that just an aside when she said, well, even if he put his head through the window, that's such a slight, violation that therefore, so she was saying it wasn't backed up by the video, or she couldn't tell from the video, and then she says, she's saying basically, in addition, moreover, even if he did, it didn't matter.
I agree with what your analysis of that is. However, if you watch the dash cam video, you also see Trooper Knowles enter the passenger side window, where that would almost invalidate her point there, because when he enters the passenger side window, and it's almost at an angle, but his head disappears. So you don't see it, it's dark outside, so you don't see his head physically enter the window, but you see his head disappear. And where it's a 250 pickup truck, so it's not like he just scooted to the front of the truck, his feet aren't moving, so you would have to walk to have his head disappear, and it disappears in the open window.
Either party cites State versus Jackson, which is a new case that was decided by the Supreme Court in December. In light of that case, do you know what case I'm talking about? Where the officer opens the door and actually puts his head in the door and sees a gun. The Supreme Court has upheld that. It's not a search when you put your body into the car. In light of that case, does that change any of your arguments?
I'm actually not aware of that case. I could further brief the court on that case, but
The facts are almost identical to this case.
Okay, the case.
Except for instead of the window, it was an open car door.
Yeah, so the only case that I found that was similar, and I apologize, I wasn't aware of that case, was State v. Weil, which was from Tuscarawas County in 1994. And that's where a car was impounded and they were searching for a murder weapon, and the officer stuck his head through a broken window and discovered a gun in the seat, and they invalidated that.
I was just wondering too, when the actual testimony, did the deputy say, or the trooper, I guess it was, did the trooper indicate in his testimony that he actually could see in the open window, he could see the slit?
During his testimony, the trooper testified that he did not enter the window. However, that's why we're relying on the video, because ordinarily the trial court's findings would be accepted, but we're saying.
I'm sorry, you're right. So he testified he didn't even enter?
Yes.
Even with his head?
Yes,
To see the cartridge.
yes, and then,
So he's saying he saw the cartridge straight from outside the window.
yes, but just the video doesn't really support that testimony. The other issue is just the height of the truck. At the angle, you wouldn't be able to see the floorboard because of how high the truck is. And you do see him lean in, and he's wearing a hat, and it disappears where if the window was closed, he would not be able to lean forward like that. The next issue is the continued detention. Mr. Gibbs isn't contesting that he wasn't able to be removed from the car for the traffic stop. However, he did provide his insurance and driver's license prior to being removed, and then he was removed just to talk and get information. And then there was a continued detention, which essentially he was sitting in the back of the trooper, or in the cruiser, while talking to Trooper Fowler, while Trooper Knowles, he watched Trooper Knowles stick his head in his car and search, and there's an exchange saying, "I'm not giving consent, why is he searching my truck, why is he searching my truck?" And that's when he's continually questioned about having a firearm in his truck, where he's denying it, and then eventually he concedes that he might have one after he observes the other trooper searching his truck. And that's where our argument is just that the continued detention wasn't at all related to the initial stop. I believe Trooper Fowler even testified that he was concerned and questioning about the firearm because if he drove down the road and shot someone else, that would come back on him. But really, that's not good policy, that's not good police work to question every traffic stop about possibly having a gun and searching the car for a firearm just to prevent shootings. I think that's what the Fourth Amendment protects against, to prevent that type of law enforcement conduct. And then in regards to the full search, at the suppression hearing, there wasn't any testimony about after they discovered the gun. Mr. Gibbs says finally, after watching his truck being searched, that he does have a firearm. It's in the book bag, so they search the book bag. And then there's a full search of the truck. There wasn't any testimony about after that point or how they discovered any illegal drugs in the truck. Exhibit 1 was just a dash camera, and the trial court judge noted that it showed the search, the full search. Just in regards to that point, the Exhibit 1 was the dash camera, so it didn't show the inside of the truck, it just showed the back of it. So there's really no evidence about how the drugs could have been found in plain view or related to searching for their firearms.
I have a factual question relating to the earlier issue. Was the window already down, or did the
Yeah.
officers?
The
or
windows were
precinct
down, yes.
officer- Okay.
I have another question too. In your first assignment there, you do cite the United States Constitution and the Ohio Constitution, but did you argue them both at trial? I mean, at the trial court level? Was your suppression motion filed under both the United States Constitution and the Ohio Constitution?
I did not, I wasn't trial
Yeah, I'm
counsel.
sorry.
Yes.
When I say you, I
Yes.
just mean, your client.
I don't believe that the Ohio Constitution was specifically cited. However, I believe it was just argued together. I don't think there was a distinction made at the trial court.
Thank you.
And then just the final issue that I have is just in regards to Miranda. There were Miranda warnings given, however, it was the continued detention while he was watching his truck being searched. In that regard, we're just arguing it was overly coercive. I think actually watching, being questioned about contraband in your truck while it's being searched would lead a person to actually make a statement that if they do have something illegal in their truck, they're going to admit to it because they are watching their truck being searched and they just are going to inevitably believe it'll be found either way.
Was the question of the full search you're talking about, where they got not just the gun, but the evidence of the drug conviction, was that argued below?
So it was argued in the motion suppressed. It wasn't really addressed during the suppression hearing.
The motion suppress argued, one, there's no basis for the stop, as I recall, and two, that, I understand kind of the coercion argument of he was coerced. You view the motion suppress arguing more than that?
I believe it did. I know it wasn't maybe addressed fully in the motion suppressed, but I think that it was an issue that was raised enough and it just wasn't really addressed at the suppression hearing, where I think the state has the burden to prove how it went from we're searching for a gun to he admitted there was a gun and we found all these drugs. There just wasn't how they found those, the drugs. And I believe the drugs were located inside the dashboard, which ordinarily that's not something you would search for a firearm, especially if you could legally carry one if it was locked in separate places. And at that point, they had already found the firearm. He told them exactly where it was in his book bag. And that's all I have if there's no other questions.
Doesn't appear to be any other questions. Thank you so
Yeah,
much.
thank you.
For your argument to the court this morning. We will take it under advisement. A written opinion will be sent to the state as well as to the appellant.